We're talking about here the Charlie Kirk assassination from last year. The suspect who is accused, Tyler Robinson, is involved in an evidentiary hearing that's happening in Utah right now. But as that is happening also, if you want to talk about this, a lot of people posted things on social media, whatever their views were on Charlie Kirk himself. Some of those were teachers that were fired. And now we're seeing one of those was a former Georgia Teacher of the Year finalist. She has now reached a settlement with her school district for alleging that she was punished for the social media comments about Kirk. Her name is Michelle Mickens. And we've seen that with several people that in free speech is what's at issue here.
Brien, again, I think the way you broke that down was better than I could even attempt to. Let's go back to the obviously the assassination. One of the worst things you could see to have happen. You would never want someone that's out there doing what they want to do, talking on college campuses, engaging in public discourse, to be shot while attempting to do that, right? And so that starts there, in mentioning the process of what's happening in the court proceedings as to lay the foundation of kind of how we got here, right? I mean, horrible. But in the aftermath of this horrible incident, you had a number of folks that were, I won't say picking sides, right, but were making comments, either in support or against. You were making people, and in this instance, that were using his past quotes to make statements of their own about this teacher here. She just quoted his statement about gun rights and how oftentimes we need incidents like this to occur so that that we can, support our gun Second Amendment rights in this country. And as you mentioned, she was terminated, never having any type of bad review, never having any type of disciplinary issue. And so she filed claim, and it's similar to our last story. Was this a retaliation for my First Amendment protected speech? And I often say a couple times, even here, that speech is free, and it is protected, but it often comes with consequences. If you make a comment or speech in a position, I should say in a place where it puts your company or organization in the light that can be negative, yeah, you may have a right to say it, but they may also have a right to terminate you, unless it's for something where you haven't, made the company look negative, or you haven't done something in a light that brings ill will or disdain to the company. This scenario with this teacher, repeating, requoting, not amending, because looked at the post, there wasn't any modification. It's a reposting that would clearly fall within the grounds of First Amendment protected speech. And so you'd have to, again, if a state was trying to stop her from saying it, have to prove narrowly tailored, compelling public interest as a way to stop it. But to terminate, you'd have to point to one of those things that I mentioned. And it can't just be that you are content specifically saying you don't like what she said.
Michelle Mickens, she was an English teacher at Georgia high schools for 24 years, and she was working in the Oglethorpe County School District at the time in 2025 when she made this post on her private page. And the Southern Poverty Law Center and co-counsel announced that Mickens and the district reached a settlement, AJC, Atlanta Journal-Constitution, saying it's somewhere in the $300,000. The thing here too is how much of the company or the organization, you're talking about the harm being done by the post that's being said, but if it's a private Facebook page, that's protected?
I don't think if it's public or private, I think it still would be First Amendment protection. She's making the comments. Her is the person. So the platform, if it was like, hey, this is my teacher page, right? Or, hey, this is my personal, mother page. I don't think that would matter as much as my profession as a teacher, and I've back to the comments that may bring some type of harm to the organization. That would be the argument from the school district. Hey, your comments are now putting us in a position where we have to defend the school and distance ourselves from you. That would be the argument that they would make. But I still think it would have to cross the line and not be First Amendment protected speech. If she was on there making hate speech, if she was on there making threats to someone, I think that would be an easy route for termination. It would point to a contract clause and something in there that some morality clause in your contract that would allow them to terminate, and I think they would be protected. I think in this scenario, if she's engaging in the public discord, social media has now become the public square. So imagine if it wasn't social media and this was taken back to a time before that, and she's just outside and she's yelling these comments. The way our First Amendment protections work would be she would be safe to yell those types of comments, and her job shouldn't be able to fire her because she hasn't said anything that was outside of the First Amendment protected speech. Now, I will say, so shifting forward to social media, that's the analogy that the court would have taken. Now, we talked about this case being settled, so it didn't make it to court. But what happens in negotiations before you get to trial? You make the arguments that I'm making. If you're on her plaintiff side, if you're representing the Southern Poverty Law Center, you're saying, if this goes to trial, this is what we're saying. We're going to tell you that, and we're going to tell a jury that this teacher has never had a disciplinary issue, that's never was put on notice for anything, for any type of probationary period, was terminated because she made a protected comment that she would lawfully be allowed to make. I don't think you win that case at trial, and that's why you settle. But I can see you have to put your mindset back to when this happened. You had a lot of people that were in positions attempting to protect organizations, attempting to protect themselves. You had legal departments that were working overtime. You had risk management departments that were working overtime, trying to ensure that they got it right. You're right here. You don't want your employees doing things that would damage your brand. For a school, you don't want teachers making comments that would now put students in a position where they're uncomfortable being taught. So there are a number of things that they have to think about when they're in this scenario. And it's not easy work to try to make sure you're managing a moment like this. I can understand and appreciate how the district got to termination. It's just the law doesn't support it. Court case precedent doesn't support it. And that's ultimately why you settle a case like this, because if you don't, you lose in court and you lose way more than $300,000.
Yeah, we've also seen this with a Clemson teacher, another person in South Carolina. And of course, we had the incident at Ardrey-Kell concerning the message that was painted on the Spirit Rock.
I like that you brought both of those up because that's on two sides, right?
Yep, right.
You have her scenario down there in Georgia where she was making comments, I won't say against Charlie Kirk, but then you have the young lady with the rock at Ardrey-Kell that was making supportive comments, and both of them in settlement. So back to the moment when it was actually happening in the risk management rooms, in those crisis management scenarios, when people are discussing this, first of all, listening to legal counsel, ensuring that they are advising you on how you proceed forward. Someone in that room at Georgia, at this teacher's school district, should have said, hey, I don't know if we have the right to fire this lady because she made a comment and said something that is protected. Back to the rock situation here. I don't know if we can tell this young lady that she has to take it down because we don't have a policy in place to support it. And so not to say that my profession is, this extremely the important profession, but oftentimes when you're in crisis management scenarios, it is. Because if you don't manage it properly, you get lawsuits.
What percentage of the $300,000 that she won in this settlement does she get?
Oh, well, it depends on the
lawyer,
right? It retains on the retainer. It depends on the retainer agreement.
33 1/3, 40%.
It couldn't be. I mean, there are caps on what you can take for certain types of cases, but then there are no caps on certain. And so, at a case like this, depending on how much legal fees they put into it, anywhere from 33 1/3 to 40% would be typical. Because remember, the law firm is doing all of the work and they're footing all of the costs. So when I say depositions and interrogatories, right? When I'm talking about hearings, this is all coming out of the law firm's pocket without knowing if you're going to get anything at the end. And so if you go set for a deposition for 4 hours, that means you're paying an attorney to be there for 4 hours at $500 an hour or $600 an hour, right? So then you're paying a paralegal to be there. You're also going to have to pay for some type of reporter to be able to get the transcription, to be able to transcribe the deposition. So one deposition for one witness, it costs you $5,000 to $10,000. And now, so it starts to add up. If you got 10 people you got to depose, you're already $100,000 into this type of litigation. So that's how cost kind of adds up. But then if you're good at what you do, you know how to manage the cost. to mitigate those things so you're not putting yourself in a situation where you're taking cases that you're not going to be able to recoup the costs on the back end. But that comes with seasoning, that comes with ability and skill, because you got folks that take cases and like, hey, I can get this big payday. Don't.
Queen City News Plus. Just search Queen City News on your smart TV's app store.